Yes, Mr. Hoskins.
Lords, good afternoon. We had a look at one step the authority referred to, certainly from our perusal of it. I don't think I need to revisit any of the submissions. I think it's sort of confirmatory in a sense, both of the, usefully actually, of the distinction between the Broad Acts principle and presumptions of evidence where someone has made it, a defendant has made it impossible to prove something. That contradistinction comes out quite clearly. I think it's paragraph 38 from memory. The final point I wanted to deal with in relation to the Broad Acts is this. In the present case, the Court of Appeal found that it isn't necessary for the claimants to rely on the Broad Acts in order to assess the extent of the overcharge in respect of the MIF paid by them. So the claimant doesn't need to wield the acts. Let me show you that in the Court of Appeal judgment. Core Bundle 2, MS 5272. Paragraph 319. We agree with the merchants that the present cases are not ones where the so-called Broad Acts principle, as explained by Miss Justice Popplewell, applies. That is to say, where the court is compelled to use a broad brush in the absence of precision in the evidence as to the extent of the harm suffered by the claimant, and so the court should err on the side of undercompensation, which is another aspect of the Broad Acts which isn't in play here. Final sentence. In cases such as those with which we are concerned, the analysis under Articles 101 and 103 will show what unlawful amount has been charged by way of the default MIF. So what the Court of Appeal is saying is the claimants don't need the Broad Acts because you can assess the extent of the overcharge by looking at what was paid and comparing it with what could have been exempted under Article 1013, which leads to the argument you see in the merchants' written cases, which is, well, if we don't need to wield the Broad Acts in this case, the schemes shouldn't be allowed to wield the Broad Acts. Our submission is it doesn't follow from the fact that a claimant doesn't need to rely on the Broad Acts that a defendant should be precluded from doing so. We say that for two reasons. One is more important than the other, and I believe the second reason I'll give you is the most important one. But if one is looking at it in sort of general justice sense, and we had this exchange with Lord Sales this morning, I explained why you shouldn't look at this simply in a justice sense, but let's just assume for the sake of this argument, you're looking at it, is it fair to allow a defendant to wield the Broad Acts where the claimant doesn't? We answer that in this way. The denial of the Broad Acts to a defendant would be particularly unjust if that were the test, in a case in which the claimant was entitled to wield the Broad Acts. And once it is accepted that a defendant must be entitled to use the Broad Acts where it is also used by the claimant, we say there is no good reason in law, logic, or principle why a defendant shouldn't also be entitled to wield the Broad Acts in cases where it is not used by the claimant. But that's a sort of general justice point. The more important point is the one that I made this morning, which is that given that the need to use the Broad Acts arises because of the need to give effect to the compensatory principle, because of the need to avoid overcompensation, in order to avoid the risk of double recovery, all those reasons for allowing the defendant to wield the Broad Acts are just as relevant in a case where the claimant does not need to wield the Broad Acts. Those principles, those three principles, are neutral as between claimant and defendant. They're seeking to arrive at the appropriate amount of compensation. It doesn't depend upon who's making the argument, claimant or defendant. And that's why a defendant should also be able to invoke the Broad Acts in a case where the claimant does not or does not need to. There's one brief point on the exemption issue, I need to come back to. It was a question that Lord Sales asked me this morning about counterfactual in 1013. And I think Mr. Cook, my junior, has pointed out I probably didn't do the answer justice in this sense, that whilst under 1013 there's no sort of strict legal requirement to have a counterfactual analysis in the same way there is, for example, for restriction of competition. And Ms. Rose showed you the O2 in Germany case, where it's quite clear the legal test is you must identify the counterfactual, you must compare the actual with the counterfactual. I think it's fair to say that in 1013 there's not such a similar strict requirement to use a counterfactual approach. But clearly there are aspects of 1013 where a counterfactual approach could be useful, and it is used sometimes. Because if one is asking what does the particular restriction add as compared to a situation where the restriction wouldn't exist, one is entering into a sort of counterfactual type analysis. But there's not the same sort of strict legal requirement. So I'm sorry, I just wanted to clarify that answer. I'm almost finished because Ms. Rose must have some time to deal with the exemption issue. So I can be very brief in relation to the other issues which Ms. Rose took the lead on. In relation to the first issue, restriction, Article 1011, you've obviously had our detailed written submissions on that. The appeals, both here and in the Court of Appeal, have proceeded on the basis that if Visa wins on this issue, then so does MasterCard. There are clearly some differences between the situations, but it's not been suggested at any stage that they are relevant differences for the purposes of the legal issues that you were addressed on in relation to Article 1011. And therefore, I simply need gratefully to adopt
Ms. Rose relied quite heavily on what she said were factual findings made by Mr. Justice Phillips, which you obviously can't do.
We had similar findings on all the critical aspects, and they're set out in our written case. So we didn't have exactly the same evidence, but we did have, for example, the same experts. So Mr. von Hinton-Reed was the expert for Sainsbury's in the tribunal case, and Mr. Dryden was the same expert. So it won't surprise you to hear that insofar as there were issues as between the experts, Mr. von Hinton-Reed and Mr. Dryden adopted the same position before the tribunal and Mr. Justice Popplewell as they did before Mr. Justice Phillips. But those detailed references are set out in our written case. I could take you through them, but I imagine you wouldn't thank me doing that at this stage. But I'd say, given that nobody has suggested the differences that do exist are actually material in terms of the analysis, then at this stage I'm certainly content to adopt Ms. Rose's submissions. And on fair share, it is correct to say that MasterCard hasn't appealed this point. The reason why it's not been an important issue to date for MasterCard is because of the way it arose before Mr. Justice Popplewell. If I can just show you that. Mr. Justice Popplewell's judgment, that's Core 2, MS, page 5709. It's paragraph 286. And this is dealing with the fair share issue. I should record that MasterCard submitted that the case law leaves open the issue of whether a global approach can instead be taken, assessing all benefits enjoyed by cardholders and merchants against all detriments. So that's the case that Visa is putting forward to you now. MasterCard's submission was that if it were necessary to decide the issue, which it did not invite the court to do, there is no requirement to establish that the benefits of the MIF to merchants exceed the disadvantage to merchants. It is sufficient that the benefits to all relevant consumers exceed the disadvantages to merchants. So you see that's the case that Visa is putting to you. This was said to be expressly stated in paragraph 241 of the Court of Justice judgment in MasterCard, and to follow as a matter of logic, that if it were necessary to prove that the benefits to merchants exceeded the disadvantages to them, there'd be no need to consider any other relevant market. And then he says, had I been asked to decide this point, I would have rejected it. And it's fair to say that we didn't ask Mr. Justice Popplewell to ask the question, but neither did the claimants in that case. So he then gives reasons why he would have found it against us. But then the final sentence, however, for the reasons I have identified, it is not necessary to do so in the particular circumstances of the case. So you have a situation in which the point was raised, the arguments were identified, neither party asked the judge to decide it, and in the event it didn't make any difference to the outcome in relation to Mr. Justice Popplewell's findings. And as you're aware, we won in front of Mr. Justice Popplewell in terms of exemptions. That's just to show you why it's simply because of the way in which the point arose in the MasterCard and AM case that it's not been appealed up by us. We were the winners in front of Mr. Justice Popplewell, and we didn't appeal it to the Court of Appeal, and we didn't appeal it to this court. But we simply made the point.
Presumably in the Court of Appeal, you could have put in the Respondent's notice if you wanted.
We would have had to. We could have done so far.
So it's just not an issue in your case.
I'm not making some sort of legal point that you must, we must have the advantage. I simply make the point. That's how it arose. That's why it wasn't significant for us until this stage. But I do make the point that it is a pure point of law. If these cases are remitted to the Competition Appeal Tribunal to be heard together, it would clearly be undesirable if the tribunal was having to conduct a detailed Article 1013 analysis on the basis of the correct law as found by this court, if it is what Ms. Rose says it is, in relation to two of the cases, but in relation to the third case, having to apply the wrong interpretation of the law, given what this court will have ruled.
But I mean, won't the fair share issue involve factual investigations, which presumably, is this right, happened in the visa case, but not in yours?
I think the evidence is there in both cases, and the Court of Appeal's remittal order was that we could each rely on each other's evidence as well. So if these cases go back, MasterCard can rely on Visa's evidence and vice versa, and that part of the order hasn't been challenged. So if it goes back, we will have the benefit of each other's evidence. So this fair share issue, if, for example, Visa has evidence on it that we didn't put in, we would still have the benefit of it according to the Court of Appeal's order. But the point I make is simply that low-level one, that it would be a very odd situation for the tribunal to be asked to apply the correct law to two of the cases and the incorrect law to one. And that's the extent of that point. Well, unless you have any further questions, I'll hand over to me.
Thank you very much, Ms. Hoskins.
Thank you.
Yes, Ms. Rose.
My Lords, I just want to add a very few points to the submissions made by Mr. Hoskins in relation to issue 2. That's the question of the standard of proof and the evidence necessary in order to satisfy the standard of proof under 1013. In general, we do gratefully adopt the submissions of Mr. Hoskins, and the issue is dealt with in detail in our printed case at paragraphs 121 to 150. That's Core Volume 1, MS 4897 to 4908. As your Lordships know, the submissions of Mr. Hoskins have identified the fact that the modernisation regulation, Recital 5, has left it to national courts to decide what is the relevant national standard of proof that's to be applied in order to determine whether 1013 defence applies, subject to general principles of EU law. That means that it's for the national courts to identify what evidence is necessary to establish the defence to the national standard. In our submission, it makes no sense to submit, as the respondents seek to do, that even though the standard of proof is a matter for the national court, it is nevertheless a matter of EU law what evidence is to be required to satisfy the standard of proof. Because how can you have a single harmonised EU requirement for the nature of the evidence if each individual member state is at liberty to apply its own national standard of proof? That simply doesn't make any sense. And we do submit that the position is clear from the Eturas case, which was shown to you by Mr. Hoskins. And if your Lordships look back, I'm not going to go back to it now, but it was paragraphs 29 to 32 of that decision. If your Lordships go back to those paragraphs, you will see that they refer not only to the question of the standard of proof, but also to the assessment of the evidence. And it's clear that the court is talking about both of those issues. As your lordships know, 1013 is a defence to a claim that an agreement restricts competition. Its effect is to exempt the agreement from the prohibition in 101 on agreements that have the object or effect of restricting competition. It doesn't follow from that 1013 is a concession that permits some limited form of undesirable behaviour. On the contrary, 1013 is an essential and integral part of the community's competition policy. Because if there is not provision for the exemption of agreements that satisfy the 1013 conditions, the result is that the community will prohibit agreements which carry with them benefits for the economy, efficiencies for the economy, the possibility of innovation, and benefits for consumers. And that is highly undesirable and contrary to the whole basis of competition policy. The result, of course, would be economic damage. And that, we submit, is essential when the court is considering how the general principles of European law identified in the Esturas case apply in this context. Because the principle of effectiveness means that it must not be impossible or excessively difficult for the 1013 defence to be established. If it's excessively difficult for the 1013 defence to be established, the result is that efficient agreements that would be beneficial to consumers and beneficial to the economy would be prohibited. Now, there are many circumstances in which it may be obvious that an agreement does generate efficiencies and benefits, but in which those benefits cannot be quantified either accurately or at all, or by empirical evidence. Not only that, the regime must be applied in accordance with the principle of legal certainty. 1013 applies to agreements from the moment of their formation. And after the implementation of the modernisation regulation, the old system, whereby companies had to apply to the European Commission to exempt their agreements, no longer exists. It is now a matter for individual undertakings entering into agreements to self-assess whether or not their agreement satisfies the conditions under 1013 at the time the agreement is made. Now, in my submission, it will be obvious that in many cases, at the time that an agreement is made, parties will not have available to them empirical data to prove or to quantify the exact nature or level of the contribution that that agreement is going to make to economic efficiencies. The best that they're likely to be able to do is to make estimates or projections based on economic methodologies. Now, they will, to the extent that they can, use such empirical data as they have to draw analogies and inferences. So they might look at what's happened in the past, they might look at what economies they expect to make, and draw inferences. But they're not going to be basing their assessment on empirical data that proves what is going to happen in the future. Even if you're assessing an agreement that's already been implemented, such as the agreements that we're concerned with in this case, it may not be possible to quantify all of the efficiencies that are generated under the agreement by empirical data. For example, there are some simple types of efficiencies, such as cost savings. If you have a joint venture, you might be able to show that a particular factory could be closed, and you could identify the running cost of that factory and say, well, that's the cost saving. That's an example of an efficiency that can be proved by empirical data. But there are other kinds of efficiencies, and one of the most important is innovation. So, for example, it's part of Visa's case that the MIF has made a significant contribution to the development of the technology for contactless payments. Because the MIF, by giving revenue to issuers on every card transaction, incentivized them to invest in the development of new technology that would encourage more card payments. There is no doubt that contactless has had massive benefits for consumers and massive benefits for the economy as a whole. I gave your lordships the pret-a-manger example yesterday. There are many other examples that can be given. Your lordships will be familiar with the way the London Underground operates and how contactless payments have revolutionized the way that people pay for their travel on the Underground and have massively speeded up that process from the perspective of the consumer and from the perspective of the operation of the Underground. They've enabled the closure of hundreds of ticket offices, massive cost savings for Transport for London. That's just an example of the sorts of scale we're talking about in these benefits. But to quantify those benefits across the economy is an impossible task. And still less to quantify with any degree of precision the extent to which the MIF has contributed to the development of contactless. Now, Visa does have empirical evidence and adduced it before Mr. Justice Phillips of the ways in which the existence of the MIF had incentivized the development of contactless. But if you ask what is essentially a counterfactual question, if the MIF had not existed or if it had been lower, would contactless have developed at all? And if so, would it have developed more slowly? That's a counterfactual question which cannot be answered by direct empirical evidence. What you do if you're addressing a question like that is you have a mosaic of different types of evidence. You might look at what's happened in other jurisdictions, such as Australia, where there's a very low MIF, and say, well, has contactless developed more slowly there? You might look at what's happened when the MIF has come down and what effect that's had on particular benefits. But you're always using such material as you have to construct a counterfactual picture based in large part on economic analysis and economic modelling. Now, the Commission itself recognises that this is the position, and you will see it set out in the Commission's own guidance. This is in Authorities Bundle 3. It's MS 1624. This is the guidance we've already looked at on 1013. We go to paragraph 56. You see at 56, I think this is a passage that was shown to you by Mr. Hoskins, there's a reference to cost efficiency. So that's the relatively straightforward case. And even there, we're talking about as far as reasonably possible to calculate or estimate the value. And then at 57, in the case of claimed efficiencies in the form of new or improved products and other non-cost-based efficiencies, the undertakings claiming the benefit of 81.3 must describe and explain in detail the nature of the efficiencies and how and why they constitute an objective economic benefit. And then at 58, dealing with prospective agreements, if it hasn't yet been fully implemented, substantiate any projections. So there's a recognition there of at least 3 different situations where you're talking about different types of evidence. And the Commission then comes on at paragraph 69 to consider qualitative efficiencies, such as innovation. And at paragraph 70 stresses their importance. Technical and technological advances form an essential and dynamic part of the economy. And if you then go on to paragraph 102, talking about the passing on and balancing of these types of efficiencies that are not quantifiable. This is page 1631. Consumer pass-on can take the form of qualitative efficiencies, such as new and improved products, And then at 103, any such assessment necessarily requires value judgment. It's difficult to assign precise values to dynamic efficiencies of this nature. The fundamental objective of the assessment remains the same, to ascertain the overall impact of the agreement on the consumers. And then at 104, there is again stress on the importance of these types of innovation. So the guidance itself recognises that you are not necessarily talking about precise quantification with data. You're talking about an overall qualitative assessment. And before I leave this, paragraph 90 in the same document, referring to fair share, stresses the point that if there's a limited restriction and obviously a large benefit, you don't have to go into a detailed analysis of fair share. And as Mr. Hoskins has shown you from the Commission's own commitments decisions, that is the approach they have applied to MIFs. They have used a proxy in relation to MIFs. Now, Mr. Hoskins showed you the commitments decisions, but the Commission has also made an exemption decision. In 2002, before the modernisation regulation came in, the Commission itself decided that Visa's MIFs at a particular level were exempt from 1011 because they satisfied the requirements of 1013. And that's the 2002 decision which we refer to in our written case. It's paragraph 144 of our case, and the decision itself is at the Appendix 1D, 7185, paragraphs 83 to 107. And if the court looks at that decision, you will see that what the Commission did was to recognise at paragraph 83 that it's impossible, let me just show this to you, Lordship, very briefly before I sit down. So it's paragraph 83 of the exemption decision. Halfway down the paragraph, it's page 7185, my Lord. At the bottom of paragraph 83, given the difficulties of measuring the average marginal utility of a Visa card payment to each category of user, some acceptable proxy for this must be found, which meets the concerns of the Commission as expressed in the supplementary statement of objections. And they then went on to say, in the following paragraphs, that under the Visa scheme, issuers incur costs which are of benefit to merchants in relation to the payment guarantee, the processing of transactions, and the provision of interest-free credit, and that it is legitimate to assess an exempt level of the MIF by the valuation of those costs. So there you see the Commission adopting an economic theory as a proxy for the satisfaction of the conditions of 1013 because it recognises the difficulties of assessment. And in my submission, that decisional practice of the Commission is entirely consistent with the principle of effectiveness and the principle of legal certainty, and inconsistent with the approach taken by the Court of Appeal, which would make it excessively difficult for the 1013 defence to be established to the overall detriment of the implementation of competition policy. My Lords, those are my submissions on the second issue.
Thank you very much, Ms. Rose. Ms. Turner.
May it please the Court, I aim to cover both ground 1, restriction of competition, and ground 2, the evidential burden point. If time permits, I may be able to make short points on grounds 3 and 4, the two subsequent grounds. However, in view of the limited time, I shall try to strip the case down to its simplest dimensions, and I will address only those points that seem to me to be essential for this Court's decision. So I begin with ground 1, restriction of competition. The way I propose to organise my submissions on this ground is in the following way. First, headline points. about the fallacy of the scheme's legal case on the concept of restriction of competition in that article of the treaty, Article 101. We say that Visa has introduced a degree of confusion about the test in their submissions. Second point, the correct interpretation and significance of the rulings of the European courts in the MasterCard litigation. Visa says that the European courts simply endorsed findings of fact which had been made by the Commission in the case before them, and they both applied at each level a limited standard of review. That, we say, is not correct. The European courts were stating how the law applies to facts that were materially indistinguishable from the facts presented by the cases which are now before this court. The third area I'll cover is this: the Korean authority is not in point. That case, Korean, concerned a situation where the Court of Appeal had held that the trial judge should have borrowed findings of fact made in a different case by the Commission, instead of assessing the evidence in the case before him to reach his own findings of fact. Here, our submission is that we have a point of law. Fourth, and finally, I'll deal with MasterCard's discrete argument on ground one, which was barely touched on orally, but is part of their written case, that although Mr. Justice Popplewell, in its case, did find that there was restriction of competition on the evidence before him, that was a conclusion which was not open to him because, they say, MasterCard's expert witness, who gave evidence to the contrary, stood unchallenged at trial. So I'll grapple now with the first of those areas, the headline points about the law. And may I begin with the text of Article 101 itself, paragraph 1, just as Visa's counsel did. And that is in Authorities 1, tab 14, page 431. Following shall be prohibited as incompatible with the internal market: agreements between undertakings and so forth, which may affect trade between member states and which have as their object or effect the prevention, restriction or distortion of competition within the internal market, and in particular those which A, directly or indirectly fix purchase or selling prices or any other trading conditions. And my Lord, you asked at the outset if that first paragraph A was relevant to our case. The answer that you received was that this concerns restrictions by object, which have the object of restricting competition, which are automatically unlawful. That is on the transcript for yesterday at page 12. Our cases, by contrast, it was said, concern allegations that these multilateral interchange fee rules have the effect of restricting competition. The provision referred to there, paragraph A, does not only concern agreements which have the object of restricting competition, as you see. And by the way, provisions which have the object of restricting competition are also not automatically unlawful. They fall for scrutiny within the framework of paragraph 3, Article 101, paragraph 3. So on its face, the article of the treaty also concerns agreements which have the effect, directly or indirectly, of fixing selling prices. That is the starting point. Second, the next question is, what then are the selling prices in this litigation with which the treaty is concerned? Here, the relevant prices to focus on are not the interchange fees, which are transfers agreed between two types of bank, issuing banks and acquiring banks. Even if you can call those transfers a price at all, we don't call them a price, and MasterCard abandoned its argument to that effect years ago, and the Commission decision records that. It's paragraph 24 of our written case. It is true that at whatever level Visa or MasterCard set a default, including zero, there will not be bilateral agreements for interchange fees at any different level, struck between individual issuing banks and individual acquiring banks. The vice of these multilateral interchange fees is not that they exclude some competitive process between the banks of reaching such bilateral agreements. At one point yesterday, it was suggested that the multilateral interchange fees are a restriction of competition because the issuers and the acquirers have no incentive to make private arrangements for any other interchange transfer. But that is not the correct focus of the case. And it appears to be, if I may say so, at the heart of why Mr. Justice Phillips went off on a different track from Mr. Justice Popplewell and from the Court of Appeal. And I would invite the Court, please, to pick up Mr. Justice Phillips's first judgment again in this connection. And you will find it in the Core Volume 2, page 5797, the relevant paragraph that I wish to go to. Paragraph 160, which you'll see at the foot of the page. And if I may return to what he said in his analysis. He says, although it's correct that the Commission has consistently referred to the fact that MIF set a floor under the MSC, the merchant charge, that was in the context of finding that there would be actual competition, note the parenthesis now, by bilateral negotiations in the counterfactual world where MIFs were absent, a process which Mr. Justice Popplewell and I have both found as a matter of the evidence before us would not in fact occur in the counterfactual. Paragraph 195 of the MasterCard CJU judgment emphasises the Commission's approach was correct because it held that the MIFs limited pressure which would otherwise have taken place in their absence, and now again the parenthesis, i.e. bilateral negotiations. It does not support a conclusion that setting MIFs in itself is a restriction of competition because they set a floor at a higher level than would otherwise apply. Indeed, the Court's reasoning refutes the legitimacy of such conclusion. And then paragraph 161, in summary, once it's been accepted or determined that there would be no bilateral agreements as to interchange fees in the counterfactual, as both Mr. Justice Popplewell and I have found, the inevitable conclusion is that a MIF does not restrict competition any more than does a no MIF or default settlement at par rule. And then if you go to the last four lines, the last sentence, the concept of the MIF being imposed or of the MIF being a flaw or of the MIF inherently and adversely affecting a parameter of competition are all attempts to explain why a MIF is more restrictive than a default with no MIF, but all fail to identify any real distinction, let alone one which arises from a difference in competition or rivalry. So you see that this judge saw the arena of possible competition as being bilateral agreements between the issuing and acquiring banks which have been suppressed or stifled. He did not interpret the European Court judgments as referring to something else, the pressure which merchants could place on their providers to bargain down the price they pay. He interpreted the European Court as saying that the MIF's limited pressure, meaning bilateral negotiation between the banks. Now, why did he reach this view?
And that's a crux point, isn't it, in your case?
It absolutely is, my lord. you see from the last sentence of 161 that he appears to have approached the matter from this angle because of Sainsbury's argument that there was a difference between a myth of zero, which it said was an imposed entity, thing, and no myth at all, which was not. And if you'd please go back to page 5789 to trace what's happened, you see the argument being summarised in paragraphs 130 and 131. Let's begin at 131. The argument was that payment to the merchant of 100% of the price of the goods or services, the par, in settlement at par, should be regarded as a fixed and obvious starting point for the transaction. In the absence of a myth, the parties would be free to negotiate as to whether a fee should be paid by the merchant to the issuer via the acquirer for receiving payment of that price via the scheme. If the result of that negotiation was, as Mr. Brealey accepted, that no interchange fee was payable, that was the result of the competitive process. In contrast, the myth was not the result of competition. It's the imposition of a fee by the scheme, which Visa is free to increase at will. For that reason, Mr. Brealey didn't accept that the no myth or default counterfactual was the same as a zero myth. He recognised the 5 expert economists had agreed those two situations were economically equivalent, but maintained they nevertheless involved a different competitive process. The former was an agreement to pay the full price, with the agreement reached as to an added fee. The latter was an imposed fee of zero. For our part, we do not agree with the argument that was put to the judge, and we would point out that what it seems to have done is to move the focus of the judge's thinking to a terrain that is not germane to the correct analysis. The correct focus in our cases is rather on the effect of the multilateral interchange fees on the individual bargaining which happens further down the line. That is, the bargaining which happens between the merchants and their banks, who provide them with payment card services, over the price which they pay for those payment card services. That is the acquiring market, as they've called it. Both of the schemes, Visa and MasterCard, accepted in this litigation that the European Court, in another case that you haven't yet heard about, made a binding legal decision which makes it necessary, in our cases, to focus attention exclusively on the acquiring market at this stage of assessing whether there is a restriction of competition, which then needs to be scrutinised within the framework of the third paragraph of Article 101. If you have Mr. Justice Phillips's first judgment still open before you, if you go in it to page 5761 in that bundle, you see this at paragraph 6. Halfway down at letter D. The central issue is whether the UK MIFs have the effect of restricting competition in the relevant market, it being common ground following the judgment of the Court of Justice in Carte Bancaire, that the market which must be considered is the acquiring market. That's to say, the market in which acquirers compete with each other to sell their services in relation to the processing of payment card transactions to merchants. And to like effect, if you have the same bundle in front of you, if you go in it, please, to page 5635, you'll see Mr. Justice Popplewell at paragraph 40, where the same question about where you should look to find a restriction of competition had been debated before him in the AAM trial. And he says at the beginning of paragraph 40 that initially there had been a debate because MasterCard drew attention to the fact that the rule has effects in different areas and where should you look for your restriction of competition. But you'll see from the last 6 lines that he concludes it's not necessary for me to address these rival arguments because in the course of final speeches, MasterCard conceded I was bound by a recent decision of the General Court in Carte Bancaire to hold that the claimants were right on this point, and the relevant market was solely the acquiring market. For your note, the Carte Bancaire case is one of our authorities. It's at page 1323 in Authorities Bundle 3, tab 28, and the relevant paragraphs are 119 and 120. So the second point is to ask oneself, where are the prices that one is concerned with? And we're concerned with the prices which are charged by the acquiring banks to the merchants, and should not be misled into looking at the interbank prices or fees or charges as though that is the focus of the case. So we now consider the question of competition over the terms of providing these services to the merchants. The reason why the collective setting by banks of a positive financial charge restricts competition over the terms of provision of payment card services to the merchants was correctly appreciated by Mr. Justice Popplewell. And the reference there is on page 5671 of the bundle before you, paragraph 156 of his judgment. It is 5671. That is where he said that so far as he was concerned, subject to something that was called the death spiral argument, which you now need not be concerned about, he found that the MasterCard MIFs did amount to restriction of competition on the acquiring market by comparison with no MIF or a lower putatively lawful MIF.
So which paragraph? I'm so sorry.
I'm sorry, that is 156 on page 5671.
Thank you.
This is his reasoning, and he explains they imposed the floor below which the charge to the merchant, the MSC, could not fall, because the acquirers had to pay at least that much to the issuers and had to recoup it from the merchants, which in turn leads to higher prices charged by acquirers to merchants through the merchant charge than if the MIF were lower or zero. And he says such a floor restricts competition because it interferes with the ability of the acquirers to compete for merchants' business by offering charges below such floor. It's no different in kind from a collective agreement by manufacturers to maintain inflated wholesale prices, which prevents the wholesalers competing on the retail market below those prices. And I'll come back to that analogy presently.
Yes, as I understand it, the case, the crux really is this, that the competition is over the MSC. The acquirers, so the merchants, absent a positive MIF, could compete for the whole value of the MSC, theoretically, and the existence of a positive MIF meant there was a proportion of the MSC which was a given, and that restricted the competition.
That's the answer, yes.
Yeah, that is your case, essentially.
That's our case on how the law stands, both as a matter of general principle, which I'm addressing at this point, and specifically confirmed in relation to interchange fees of a similar kind by the European courts in the MasterCard litigation, where they faced similar arguments of principle.
Thank you.
So, in short, if I can summarise what I've just said then, these collective interchange agreements they restrict competition over the terms received by the merchants, and that is because their effect is to fix and thereby remove the acquirer's incentives to compete over a part of the selling price, which is charged by individual acquiring banks to individual merchant customers. They replace, through effect, competition over the whole of the price charged, with part of it being collectively predetermined, as my law points out. Now, I've mentioned part of the price. I should make the point that it is well-established law that it's equally problematic, not just to fix the entirety of the price, but to fix a part of a price charged to customers. Just as problematic to do that as it is to fix all of it. So, for example, if rival steel makers agree that they'll each charge a surcharge, an alloy surcharge to customers on top of the price that they'd otherwise set, that qualifies as a restriction of competition. And if I may briefly show you that being considered by the court, in the second authorities bundle, at tab 23, page 856, you will have the Krupp-Tyson authority. Krupp-Tyson. If you go to page 867, the scene is set in paragraphs 4 and 5. Paragraph 4, following reports in the press and complaints, the Commission asked a number of stainless steel producers for information concerning the application by those producers of a general price increase, which was called the alloy surcharge. The alloy surcharge is a price supplement calculated on the basis of the prices of alloying materials. It was added to the basic price for stainless steel. If you go to page 881, you will see from paragraph 82 at the foot of the page that the subject matter of the agreement that they were concerned with as breaching competition law was the use with effect from the same date by all the producers of stainless steel products of identical reference values in the method for calculating the alloy surcharge, a method that had been used previously with a view to securing an increase in the price of stainless steel flat products. And finally, if you go forward to page 894, paragraphs 156 to 158 are the relevant parts. 156, before examining, for the sake of completeness, the anti-competitive effects of the agreement, the Commission rightly considered it constituted a cartel caught by the prohibition, parallel prohibition in the European Coal and Steel Treaty as it was, since its aim was to fix a component of the final price of stainless steel flat products through the use by the producers concerned as from the same date of the same reference values for calculating the alloy surcharge, as is confirmed by the case law on the application of now what has become 1011, and there's your paragraph A of the treaty. The prohibition of agreements and concerted practices which directly or indirectly fix prices also extends to agreements relating to fixing a part of the final price. 158, in this case, the Commission also found that the agreement was liable to affect competition considerably, since first the undertakings concerned represented more than 90% of sales of these products, and second, the increase brought about by the surcharge could represent up to 25% of the final price, so it was material. Now I would wish to bring that home, in case it suggested, well, that is not a case like ours, where there has to be cooperation through a scheme. Let us suppose the following. Suppose that all the acquiring banks in the country sit down together and directly agree we will all charge our merchant customers a minimum fee for every card transaction. We'll say that it's 1% of the value of the purchases that every consumer makes when they pay with a card. And then they go off and do that. Not even Visa and MasterCard could doubt that the treaty prohibition would apply to such an agreement because it has the naked object to raise selling prices directly to the customers. We are one stage away from that, and only one step. Precisely the same is true under the treaty of a collective arrangement between MasterCard, Visa and their banks, like the ones now before this court, which has the effect of imposing substantial charges on the merchants. It is straightforward. And that takes me on to the fourth observation. Visa says, through counsel yesterday, perhaps in both of those cases, object or effect, where in any of that do you find a restriction of competition? Ms. Rose referred yesterday to the Commission's horizontal cooperation guidelines to help explain to this court the concept of restricting competition. That was her next step. Well, may I invite you, please, to return to those two. They are in Authorities, Volume 3, at tab 31, at page 1645. They begin at 1638. On page 1645, you were taken to, correctly taken, to the heading Restrictive Effects on Competition towards the foot of the page, and paragraph 27 in particular. The first sentence of paragraph 27 reads, for an agreement to have restrictive effects on competition within the meaning of the treaty, it must have or be likely to have an appreciable adverse impact on at least one of the parameters of competition on the market. In other words, the things that people compete over, such as the price or the output, the quality, the variety, or indeed innovation. It goes on, agreements can have such effects by appreciably reducing competition between the parties to the agreements, or between any one of them and third parties. This means that the agreement must reduce the parties' decision-making independence, a point then that Ms. Rose at that point closed this and took as the point. But look to see how that is then defined in the last two lines of this paragraph. That can be done by influencing the market conduct of at least one of the parties by causing a change in its incentives. In the case of these multilateral interchange fees, what they do is precisely to influence the market conduct of the acquiring banks by causing a change in their incentives. The acquiring banks have now got an incentive to pass the full amount of the MIF onto their merchant customers and thereby charge a price to the merchants, which includes the jointly agreed minimum financial charge to every one of their merchant customers. Now, this point was explained, and almost precisely in terms that fit with the Commission's guidance, by Mr. Dryden, who was AAM's expert economist, in the oral evidence, in the visa trial, on days 19 and 22 of the hearing, referred to by Visa in their written case. It was simply not properly understood by Mr. Justice Phillips. And may I invite you in this regard, please, to pick up the applicant's additional documents file. And go in it, please, to page 7455. Where I hope you should have the first page of the transcript of the hearing on day 22. And then the following page, 7456, is the manuscript version of the evidence that was given by the economist. The relevant part is on the second-hand side, the right-hand column, at the top, page 151, Mr. Justice Phillips. And he said, if you remove the myth, line 6, if you remove the myth from the MSC, the basic element of cost, why does one assume the MSC comes down to the level without the all-the-way down effect? Why does one assume that the bargaining process, function of supply and demand, doesn't stay up near the existing level of the MSC? Why does it come down? The answer given by the expert was, I understand it's because in this market, I'm thinking particularly of acquirers competing to supply merchants with acquiring services, I think it's helpful to think of competition as a two-stage process. The second stage of the process is after the MIF's already been determined. So the cost base of all the acquirers has been established. That fixes their reservation price, their bottom line, as it were, because they're not willing to sell at a loss. But competition among acquirers is intense. That's the intensity of competition among acquirers. So that's going to bring one down towards, or to very close to, the reservation price, which is given by the costs, including the MIF. That's what happens in the second stage of competition. There is, in effect, a prior stage of competition in which the acquirers collectively, together with the issuers, decide what the MIF is going to be, and therefore, in effect, they're making, before they go out to play their competitive game, they're deciding the terms on which they're going to play that competitive game with each other by virtue of deciding in advance what the MIF is going to be, and therefore what their costs are going to be, and therefore what the reservation price is going to be. So it's that prior decision as to the MIF that changes the competitive outcome. So that was how he described it, and why you see he focuses on an element of the competitive process, which he says is the relevant restriction happening, the first stage of the two stages of competition. Or in the wording of the Commission, this is the changing of the incentives of one of the parties to the agreement vis-à-vis their relationship with third parties down the line. We then see this being referred to for completeness in the further part of his evidence referred to by Visa in this case, which you should have in Appendix 1C, bundle page number 6722. That's the front page, and you go in it to 6736.
Now, those of us working from hard copies don't have an MS number in this volume, but we do have the page number across the middle of the bottom of the page.
I'm obliged, it's 1546. I'm not going to read this out extensively, but I'll direct your attention to the following. On page 114, beginning at around line 9, the expert says again there, when acquirers reach a common understanding of positive MIFs compared to a counterfactual of zero MIFs, they've agreed on what their cost base is going to be in the subsequent process of competition that they're going to engage in with each other. And by agreeing on a higher cost base, they have in one sense regulated by effect their prior agreement on the MIF. They've regulated their future conduct, which is they've set a floor for how far down that competition among them is going to push the MSCs. Or to put it in other words, through prior agreement, they've changed in a common way their own incentives for how they compete subsequently with each other. And then if you look across to 116, the answer to the cross-examiner's question beginning at line 4, going all the way over the page, develops that. If I pick it up around about line 20, he's referring to the icing on the cake, the competition above the part that's fixed, remaining constant and still lively and vigorous. That doesn't change. The MSCs go up because the reservation price has gone up, and the range over which the competition is happening, which always take you to the floor, is lower, I should say smaller, and it's lower because the floor has gone up. That's my hesitation for giving a yes-no answer to the question of process, competitive process, because you could say, no, there's no change in the process if you're focusing on the icing on the cake and how deep that's going to be, but there is a fundamental change in the process in the sense that the reservation price of all the sellers has changed through, in effect, their prior agreement as to costs in a common way. So that is the crystallization of the way in which competition is affected in this case. In a nutshell, moving on to one of the points that was made forcefully yesterday, the vice of these MIFs is that they are a collectively agreed financial charge which is imposed on the consumers, the merchants. That is why the notion of a zero collective charge, or nothing, as being an arbitrary point on a scale, as Visa sought to say yesterday, is wrong. The making of a collective agreement between the sellers, which imposes nothing at all on the prices bargained over between individual banks and their merchant customers, is not changing the incentives of the acquiring banks, and it's not restricting competition. So that's why nothing is important. And the next point is this, my sixth observation. It's also why it's wrong to regard nothing or a zero interchange fee, which is equivalent, as paradoxically also a restriction of competition, because of this notion that settlement at par between the banks is restricting a possibility of interchange fees going in the other direction, namely being paid by the issuing banks over to the other group, the acquiring banks. And the point here is that these interchange fees, which have the effect of collectively setting a minimum price to customers on either side of the scheme, suffer from exactly the same vice, which the mere absence of collective monetary charges doesn't. And if I may then reverse the illustration that I gave the court a few moments ago, suppose, if you would, that all the issuing banks get together now and they all agree to impose minimum prices on all of us, the cardholders, for using our cards. That would be unlawful fixing of selling prices too. And in the same way, it would be unlawful for the banks, those banks, to make an agreement which produces that effect through collective interchange fees which now pass from the other group, the acquirers, over to the issuers. Yesterday, Ms. Rose developed in oral argument this point by saying, well, if you have settlement at par, it feeds through to a restriction on the ability of a merchant to say to its provider, you should pay me for the service I give you of accepting your cards. It's roundabout transcript, pages 45 or 46. You should pay me. Now, the idea that settlement at par prevents merchants from selling their services to their providers, to the acquirers, is a completely different economic idea or context or market where we, the merchants, we're now no longer the buyers, we're selling something. And it's also fanciful. This point has never been advanced by the schemes as a realistic or likely counterfactual to the myth, and for good reason. And for your note, my lords, I won't go to it, Mr. Justice Popplewell at paragraph 43, page 5636 in Core Volume 2, makes the uncontroversial point that a counterfactual must be something that is likely to happen in the absence of the impugned conduct and realistic. My seventh point is this. A further error in the exposition yesterday by Visa's counsel is the following. She said to you a number of times that all this MIF is doing is, and I quote, transferring revenues or costs to one side or other of a two-sided system, a seesaw effect. That's, for example, page 54 of the transcript of yesterday. You rob Peter to pay Paul. And this enabled her to portray the financial charge simply as a balancing mechanism, not as a means by which a group of sellers have made an agreement which imposes costs on all their customers, some of which they take out as profit. Yet that is exactly what these multilateral interchange fees are. You do not merely have some adjustment moving money between two groups of customers, the cardholders and the merchants. And this point was indeed put most forcefully by Mr. Justice Phillips, on whom Visa in this connection rely, in his second judgment in these proceedings. May I ask you to turn for a moment to his second judgment, which is in the core Volume 2 file at page 5826. I'm assuming you're using the electronic pagination for this.
Yes.
5826, at paragraph 52. Does the court have that? And I ask you to look 4 lines down. And this is what the judge now says. Although framed as a mechanism to balance the two sides of the card market, it can be looked at another way. Issuers are combining to impose a charge on merchants, which increases their revenues and their profits, out of which the issuers decide to invest in improving their product by innovation and otherwise, not least so they can make more profit. And then he goes on to consider how that applies for the context of Article 101.3. But my point is the following. This judge now says that the very problem that he's analysed in his first judgment in a particular way can be looked at from a different angle. And the issuing banks do skim off an unknown proportion of the revenues that they get from these interchange fees without passing that money on to their cardholders in the form of air miles and the like to promote our increased card usage. This accurate description given in paragraph 52 by Mr. Justice Phillips of these MIF agreements should have caused him to analyse in his first judgment what he found as being a restriction of competition, because he is, of course, referring to precisely the same facts as he was dealing with in his first judgment. And that is for all of the reasons of principle that I've outlined, and it is because the legal position was confirmed decisively in the European MasterCard litigation, to which I will turn in a moment. So analytically, if I may stand back, the position is this. The first question is to ask, are the banks combining so as to impose a charge on the merchants? If so, then you should pass Article 101, first paragraph. And then a factual question, one of the factual questions which will arise properly under the third paragraph, will be how much of that money sticks in the pocket of the issuing banks rather than being transferred across to the cardholders. But that is for the later stage. And so, if I may draw the strands together, I've sought to cover the main points that you were hearing yesterday from Visa. The crux of the argument before this court today on Article 101, first paragraph, is essentially this. Where you have a collective agreement between sellers, which fixes a part of the price paid by individual customers to individual sellers, and so renders it immune from competitive pressure by the customers, and in circumstances such as these, does this amount in law to a restriction of competition? We say this raises clearly a point of legal principle concerning the right way to apply the rule in Article 101, paragraph 1. This is not a mere factual matter, let alone a matter of complex economic assessment. The scheme's argument, which it has been ever since they first raised it before the European institutions a decade ago, is that what I've described to you, that proposition does not amount in law to a restriction of competition. And their essential contention, building on what Miss Rose said to you yesterday, is that when you are dealing with this first paragraph of Article 101, the court can and should focus exclusively on the part of the price paid by merchants to the banks, which is not covered by the price fixing. You look at that, the lively competition which remains over the icing on the cake, the acquirer's margin, and then you ask yourself whether, as a matter of fact, the process of competition with respect to that part alone remains strong. And that explains the reference that Ms. Rose gave to you yesterday to the evidence in her trial from one of the acquirer witnesses who said that on that part of the price, the competition remains strong.
The competition would be strong not just in relation to the margin, but in relation to any other costs that the acquirer incurred over and above the MIF. There'd be overheads and things like that.
Yes, to their individual costs.
The individual costs, yeah.
Absolutely.
Yes.
And the point, I'll come to this directly in a moment, that was made by the Commission to drill into this in slightly more detail, is that sort of competition, that is the normal formation of prices on the market, an individual buyer and seller negotiating with those sorts of considerations in mind. But where you predetermine an element of the cost, that is not. That is a departure from this situation. And so it is that you can see that the material point in the case is that there is an unspoken major premise behind Visa and MasterCard's analysis, and it is undoubtedly a legal issue. The National Court has first got to interpret and understand the correct meaning of the concept of restriction of competition, which is used in Article 101, first paragraph, before it goes on to apply it. And in the cases below, Mr. Justice Popplewell did, but Mr. Justice Phillips in the first judgment on this point did not. With that, I move to the European MasterCard litigation, the second of my topics. The issue of what it was that the European courts actually decided specifically in these MasterCard judgments. Our case is that the European courts in those judgments were articulating points of principle about the correct approach to how you find a restriction of competition, which applies equally on the facts of these cases. And the Court of Appeal made no error. The starting point, please, is the analysis then in the Commission's decision itself. And if I may ask you to pick up Appendix 1D and go in it to page 6895. I will be revisiting some of the recitals you've seen and some others, but looking at them with different eyeglasses.
I think we have the same problem, Mr. Turner. 1B?
What 1D?
1D.
Sorry, 1D.
Thank you.
Yes, it's the European Commission's decision. So it's in 1D, should be in 1D, and the page that I'm going to in it, the electronic numbering is 7011. So this is the heading, Restriction of Competition in the Acquiring Markets. Ms. Rose rightly took you to this section because this contains the analysis.
Sorry, the page again, please.
Yes, I'm sorry, 7011. And now, I hope with the explanation that I've given about how all of this works in general, you can see what the Commission is saying and appreciate its reasoning with fresh eyes. MasterCard's MIF constitutes a restriction of price competition in the acquiring markets. In the absence of a bilateral agreement, the multilateral default rule fixes the level of the interchange fee rate for all acquiring banks alike, thereby inflating the base on which acquiring banks set charges to merchants. prices set by acquiring banks would be lower in the absence of this rule and in the presence of a rule prohibiting ex post pricing, essentially settlement at par. The MasterCard myth therefore creates an artificial cost base. Please underline the word artificial, because our proposition is that means, because it has come from the collective agreement, that is common for all acquirers, and the merchant fee will typically reflect the costs of the myth. It is the costs of the myth that are the part of the cost base which are the artificial part. To return to my Lord Hodges' point, there are other costs which are normal and which are not artificial. And then they say this leads to a restriction of price competition between acquiring banks. And the word "this" shows you that the European Commission is saying that what we have just said is the reason for why we find a restriction of price competition. There's nothing about what comes later that Ms. Rose took you to about a process of bilateral interchange agreements being suppressed. So that is recital 410. If you then go, please, you've seen a lot of this before, go straight to 448, which I don't think you've seen yet. That is on page 7024. If you look 4 lines down in 448, the Commission says the decisive question is whether, in the absence of the myth, the prices acquirers charge to merchants at large would be lower. This is the case because the price each individual bank could charge to merchants would be fully determined by competition, rather than to a large extent by a collective decision among or on behalf of the banks. And then if we go forward, please, to 457. That's on the facing page. You'll recall the last 2 lines, which you've looked at already, state the collective act of competing undertakings to raise charges for consumers is subject to the prohibition of what is now Article 101, first paragraph of the treaty. That is not an observation, that is a definitive statement, so far as they are concerned, of the position. 458 shows that it is a legal assessment because it begins, if the concept of a restriction of competition within the meaning of the article had to be interpreted as MasterCard suggests, then it would be entirely deprived of its effet utile. So that shows that they are talking about a legal assessment. And if you go over the page to 459, you have the point to pick up again my Lord Hodges' observation about what's an artificial cost and what isn't. In the absence of MasterCard's myths in 459, they say, the prices acquirers charge to the merchants would not take account the artificial cost base of the myth and would only be set taking into account the acquirer's individual marginal cost and the markup. And then the first sentence of 460, statements of retailers demonstrate they would be in a position to exert that pressure if acquirers were not able to refer to interchange fees as the starting point, that is to say, as the floor for negotiating the MSC. The reference to that pressure is referring back to what has just been referred to in 459, namely, you can drive the prices down to the level of the individual costs and the acquirer's markup that they choose to make in terms of provision of the service. That is the pressure which is being referred to, the word which then finds its way all the way through to the judgments of the European Court, as we will see in a moment. Ms. Rose laid her case about the European Commission's decision meaning something quite different on the middle section of this recital, 460, where there's a reference to the negotiation on bilateral agreements. And you'll see about 8 lines up after referring to a possibility of what might happen and supposition if acquirers attempted to enter into these bilateral agreements, you find this, about 8 lines up from the bottom. In the long run, This process can be expected to lead to the establishment of interbank claims and debts at the face value of the payment. That is without deducting any interchange fees. A multilateral rule that by default sets a certain interchange fee rate in the absence of bilateral negotiations prevents this competitive process. In the absence of such a rule, and in the presence of a prohibition of ex post pricing, acquiring banks would eventually end up setting their MSCs merely by taking into account their own marginal cost plus a certain markup. Now, this essentially, yes, is referring to a transitory supposition in the middle of the paragraph, but that is not the gravamen of the reasoning in this decision, as all the other recitals, and indeed the conclusion that we'll come to, and the way that the case was put in the European Court, confirm. If you go to paragraph 517, to this paragraph at the foot of the page, the Commission says, note that in the Commission's view, in the absence of a default myth, banks may or may not enter into bilateral agreements or interchange fees. I'm sorry, I should have said footnote 517 at the foot of that page. So the existence of such bilaterally agreed interchange fees is no prerequisite for the viability of the MasterCard payment scheme. So the Commission is clearly saying that the presence or making of bilateral agreements is not something that is essential to its reasoning. Today I heard a variation on that yesterday from Visa's counsel, which was, well, they say that it doesn't matter that whether or not there's bilateral agreements, but they certainly are placing central emphasis on there being negotiations for bilateral agreements. That is a fanciful sophistication of the argument, and it's not the way that this is properly to be read. If you take the last sentence of footnote 517, in the absence of a default myth, prices established on both sides of the MasterCard scheme, as set out in section 7341, each bank determines its service levels and prices in a manner that maximises its individual profits. You see a further confirmation of this. This follows through to recital 551 on page 7048. Follow that through, which you were taken to briefly yesterday. And if you look coldly at what is said in recital 551, take Roman 2, you see the basis on which this is now being put by the Commission. So Roman 2, acquiring banks charge merchants for the services they provide, similarly to what happens on the issuing side, prices are set according to the profit maximising level of each individual acquirer. Banks decide about the price they charge to merchants without that price being predetermined to a large extent by a myth. And you see the same thing echoed in 552, the last two lines. So it is clear from this that the concern of the Commission relates to the introduction of an artificial cost base through collective agreement. Two further recitals, and then we put this away. 522 on page 7041. This was picked up by the European courts, as you'll see in a moment, why I take you to it, as an essential part of the Commission's reasoning.
Sorry, paragraph.
522 on page
Thank
7041. So the main reason I'm taking you to that is because you'll see in a moment the European courts, in their recording of what the Commission's basis of its thinking was, refer to this recital. 522 refers to the fact that the MasterCard members collectively have market power vis-à-vis the merchants and their customers. That this is the must-take cards point, that the merchants find it difficult to say no if somebody wants to pay by card. The myth allows them to exploit that collective market power by effectively putting a floor under the service charge charged to merchants. In the presence of a myth, the marginal cost of the acquirers are inflated, thereby setting a floor under the merchant fee. And by floor, given this context, it's clear it doesn't mean zero, it's meaning a financial charge. And finally, to complete the survey, the conclusion on restriction of competition is on page 7077. under the heading Conclusion on Article 81.1 at 664, you see a short statement of the basis for their decision that there is something which in law qualifies as restriction of competition. We've made the point in our written case that that wording exactly matches the executive summary of this decision on page 2, which is 6899 of the bundle. So, to summarise, it's perfectly clear, we say, from all of this decision read fairly and its conclusion, what its essential reasoning is. We go from it, please, to the General Court judgment, which is in Authorities Bundle 2, at tab 24. I'd ask you, please, to go first, page 921. Where it starts. I'm sorry, 935. 935. Now I'm going to pick up the pace, if I may, with the court slightly. Under the heading Restriction of Competition on 935, the General Court, between paragraphs 27, or in paragraphs 27 and 28, is summarising, as it understands it, the basis for the European Commission's thinking, its case. And you'll see, in 28 in particular, according to the Commission, the members of the MasterCard organisation collectively exert the market power vis-à-vis the merchants. Thus, the MIF had the effect of inflating the base of the service charge, and so on. And 4 lines up from the bottom of 28, it follows from this that the MIF examined by the Commission in the contested decision led to a restriction of price competition between acquiring banks to the detriment of merchants and their customers. There you then see recited what the court sees as the material recitals for the conclusion reached by the Commission. If you then go to page 948, you have paragraph 125, which I ask you to read to yourselves, but essentially it is again showing the legal basis for the European Commission's decision and referring to the relevant recitals so far as the court understands it. Then at 949, page 949, paragraph 130, you had this said about 6 lines down in 130. The applicants also take the view the Commission wrongly concluded that in the absence of the MIF, bilateral negotiations would be held between issuing banks and acquiring banks, and that such negotiations would in due course lead to the disappearance of interchange fees. Now, on that point, there was an allegation made by the applicants appealing against the Commission decision, and the reasoning and responses at 133, 3 lines from the top, although the Commission referred to such negotiations in 460 to the contested decision, it did so essentially in order to point out that in a MasterCard system operating without a MIF, acquirers accepting interchange fees on a bilateral basis would risk failing to remain competitive in the acquiring market, and therefore in the absence of a MIF, it was to be expected that interchange fees would in due course cease to be charged on the settlement of transactions. In other words, this was a transitory phenomenon, and the court is setting right the understanding of the applicants that this had been a material basis of the Commission's reasoning. It says that it's referring to that only as almost a supposition element of the reasoning, which would lead eventually to the steady state of there being settlement at par, which then forms the correct counterfactual. If we go over to paragraph 138 over the page, we have the observation by the General Court that in the earlier paragraphs of the contested decision, 401 to 407, just before the one I first took you to, the Commission said it was an open question whether this arrangement had the object of restricting competition. but it decided, as you see from the quote, not to reach a definitive conclusion about it. And if you go over the page, the General Court, after considering that in the subsequent paragraphs, says at the top of the page, paragraph 140, in that regard, it is helpful, that must mean to this case and to analysing it, to point out that Article 1011A, the paragraph my Lord Reid referred to, expressly provides that measures which directly or indirectly fix selling prices constitute restrictions of competition. And according to the case law, the purpose of that paragraph is to prohibit undertakings from distorting the normal formation of prices on the market. But they go on in one for one to say that because the Commission didn't expressly rely on that, we have to analyse this as an object case.
No, the facts case.
I'm sorry, as an effects case. Apologies. Now if we go, please, to page 954.
Sorry.
Paragraph 163, you see there the General Court clarifying that an effects analysis in this context means essentially confirming the supposition that the MIF does actually, in the real world, set a flaw by examining the facts. And it says, well, the Commission didn't just treat this as something that could be regarded as a restriction by object without needing to analyse what happens in practice. They went on to do that by asking themselves, does this charge result in there being a flaw for the prices charged to the merchants? And finally, if we may go back to the crucial paragraphs 142 and 143 on page 951, those must be read together. And in my submission, they are entirely unambiguous. 142, the applicants submit in essence that the fact that the MIF had an impact on the level of the charge, the merchant charge, doesn't affect competition between acquirers, because the MIF applies in the same way to all acquirers and operates as a cost common to all of them. Thus, the prohibition of ex post pricing, settlement at par, would effectively impose a MIF set at zero, which from a competitive aspect would be equivalent to and just as transparent as the MIF, the only difference being the level at which it is set. This line of argument cannot be accepted, since it's acknowledged that the MIF sets a flaw, as in our case, and insofar as the Commission was legitimately entitled to find that a MasterCard system without a MIF would remain economically viable, as in our case, it necessarily follows, please underline, that the MIF has effects restrictive of competition. By comparison with an acquiring market operating without them, the MIF limits the pressure which merchants can exert on acquiring banks when negotiating the merchant charge. How? By reducing the possibility of prices dropping below a certain threshold. It's entirely consistent with the reasoning you saw from the Commission.
And that's a proposition of law. It necessarily follows as a matter of law.
Yes. It's a line of argument, and they say that if you take these facts, it necessarily follows. Now, Visa say that this is ambiguous, in their written case at least. They said it refers on the one hand to limiting the pressure which merchants can exert on their banks in bargaining, but on the other hand to the collective fee increasing the price. And aren't these two separate matters? They're not two separate matters. They are connected. They are the same thing. It is the inability of the merchants to bargain the price down below the collectively set level which results in the increase in the total price. It's the mechanism or means by which that is brought about. The last paragraph that I wish to draw your attention to in this is at the foot of that page, 147. This is the general proposition that competition on a part of a price which is restricted still amounts to a engaging Article 101, paragraph 1. You'll see the last four lines, last sentence of 147 says The fact there's competition on price of the charge up to a limit attributable to the existence of the myth, which of course, pausing there, is what Miss Rose said was the key to the case that Mr. Justice Phillips found on the evidence before him at trial. The fact that there is such competition does not in any way preclude the Commission from finding that the myth falls within the scope of Article 101, first paragraph, as it now is. So that's the answer. We then go to the appeal to the higher court, which was purely on law. And if I may begin with the Advocate General Mengozzi, the Advocate General, he explains too the basis of the Commission's legal conclusion that there's a restriction of competition. He also has correctly understood it. And you see that if you go in his opinion, at page 995, it's the beginning of his opinion, to a paragraph which is numbered AG6, Advocate General 6. You have that, it's near the top of the page. In the decision at issue, the Commission considered that the decisions setting the myth, which it characterised as decisions from the Association of Undertakings and so on, restrict competition between acquiring banks and thereby infringe that article. In that, please underline, that's the reason, that they amount in fact to setting a minimum price for the MSC. That crystallises what is the concern. They have that effect. And if you go forward to page 1009, paragraph 54, you have the Advocate General discussing what the competitive process is that he says is interfered with. In the present case, the Commission examined the competitive process that would have developed on the acquiring market in the absence of the myth. So forget the bilateral negotiations. And concluded that in the absence of the myth and with a prohibition on ex post pricing, the prices charged to merchants by acquirers would only be set taking into account the acquirer's individual marginal cost and his markup. According to the Commission, the uncertainty of each individual acquirer about the level of interchange fees which competitors bilaterally agree would exercise a constraint on acquirers, and so that, in the long run, this process can be expected to lead to essentially settlement at face value. So the competitive process that he's concerned with being interrupted is that there's no longer the bargaining over the individual costs, there's now this slice of collectively agreed costs too. And because they have certainty that there's going to be the same charge imposed by all of their brethren, the acquiring banks can safely pass it on in their own charges to their individual merchant customers. The last paragraph to show you in the Advocate General's opinion is paragraph 64, which begins on 1011, but the relevant part is at the top of 1012. If I may begin at 1012 at the top. Here he's discussing the point that the Commission chose not to analyse this as a restriction by object. And he says at the very top of the page, 1012, in any event, while it's true that in the decision at issue the Commission didn't adopt a definitive position as to a possible anti-competitive object of the myth, and accordingly was required to assess the effects, the fact nonetheless remains that in a situation involving collusion, which directly affects the pricing mechanism, its ability to distort the normal development of prices on the market may in fact be easier to demonstrate. In that regard, I observe that in the judgment concerning Austrian banks, the General Court, without being contradicted by the Court of Justice, asserted that in order to establish whether a pricing agreement implemented by the participating undertakings has had an actual impact on the market, and the quotation is important, it's sufficient that the agreed prices have served as a basis for determining individual transaction prices, thereby limiting customers' room for negotiation. And he explains, although admittedly the collusive agreement at issue in that case was considered to be restricted by object, the same analysis should apply in this context too. And so it is that you see that so far in the survey of how the European Court institutions, the judiciary, looked at it, and we'll turn now to the highest court, they fully understood the Commission's case. It was not what Visa has said it is, and they articulate the correct proposition of law, which applies the general law of how you analyse restriction of competition to circumstances of cases like these. So finally we come to the higher court, and we go in their judgment, which is in tab 25, to page 103. It begins at page 103.8. May I ask you to turn first to page 1070, where you have paragraph 180. Here, the higher court says this. In the present case, as is apparent from 181 and 182 of the judgment under appeal, the General Court, the arguments essentially put before the General Court, which aren't contested, didn't include the argument now advanced by Lloyds in the context of the present appeal, according to which in order to assess restriction of competition in its proper context, you have to take into account the two-sided nature of the system in question. So this is a revisiting of the point that you should look more broadly than simply at the acquiring market. And they say, and I'm picking this up from 5 lines up, as is evident from paragraph 90 of the present judgment, and from the very wording of Article 81, now Article 101, from the very wording, where it's established that a measure is liable to have an appreciable, and that means a collusive measure in context, an appreciable adverse impact on the parameters of competition, same language as in the Commission's guidance, such as the price, the quantity and quality of the goods or services, and is therefore covered by the prohibition rule, therefore covered, please note, such advantages can be considered only in the context of paragraph 3 of that article. And the final paragraph to show you, again from the higher court, is 195. And this is the final conclusion of the debate about whether there's a restriction of competition. The higher court is addressing the proposition that the only difference between pricing to merchants with or without a MIF in the background is the level. And they say, as the Commission rightly points out, so approving the Commission's line of reasoning, the judgment under appeal is not based on the premise that high prices in themselves constitute an infringement of the treaty. On the contrary, as is apparent from the very wording of 143 of the judgment under appeal, it's the one that we looked at a moment ago, high prices merely arise as the result of the MIF, which limit the pressure which merchants could exert on acquiring banks, with a resulting reduction in competition between acquirers as regards the amount of the merchant service charge. So again, the right focus is the service charge paid by the merchants in total to their providers. To summarise, my lords, there's no doubt that the European courts in these MasterCard judgments stand as legal authority on how the prohibition rule in the first paragraph of Article 101 applies on facts such as those which are agreed in the present cases. And this was correctly understood by the Court of Appeal. And I'll, in the interest of time, just show you a couple of references. We go first to Core Volume 2, the Court of Appeal judgment, and open it at page 5239. The key paragraphs are paragraphs 144 to 146 on page 5239, where the Court of Appeal begins by saying at the outset, it's clear from paragraph 142, that's the General Court judgment we looked at a moment ago, that they were dealing with the same arguments that were addressed to us. And then they run through the line of argument, and at 146, they refer to what the General Court said as the answer to that line of argument, and in the last sentence say, this reasoning seems to us to be a conclusion of law based on the factual premises stated, which it may be noted are precisely the same factual premises as are agreed in this case. And one further reference, in the interest of time, if we go to page 5241, over the page, 156, I beg your pardon, letter G. This says, in our judgment, the proper analysis of the Court of Justice's decision is that endorse the counterfactual adopted by the General Court as a matter of law, rejected various arguments, and look at the third argument, please, Roman 3, that the imposition of the MIFs did not restrict competition between acquirers because the merchants could still compete in relation to the parts of the charge unaffected by the MIF. It's clear from that, certainly the last part of it, that what the Court of Appeal's language is loose, but what they should say is that the Court of Justice endorsed the significance of the counterfactual adopted by the General Court as a matter of law. For the avoidance of doubt, we would agree that the Court of Justice here was not saying there was a counterfactual found to be the case in the European proceedings, and therefore we must find that the same counterfactual applies here. What they are saying is that on the basis that the same counterfactual settlement at par, as was found, established by the Commission on the evidence in that case, is agreed here, the analysis of it, the same analysis of it applies. The final point which is made by each of the schemes about these judgments is that they should be viewed by this court merely as involving a review of complex economic assessments that were made below by the administrative agency, the Commission, and not as adding the fiat of judicial authority to any points of law or legal reasoning in the Commission decision. I'll deal briefly with it. It's wrong. The appeals to the European Judicature were full appeals which were on the basis of an in-depth review both of matters of law and fact. And on that, if I may invite you to go back to the Court of Justice's judgment in Authorities Bundle 2 for a moment, tab 25. If you go in there to page 1064, there is a relevant exchange and a finding by the court that you should see. On page 1064, you have at the top paragraph 141. It was a submission by Lloyds Banking Group. Lastly, according to Lloyds, the General Court applied an inappropriate standard of judicial review. As is apparent in particular from 169 of the judgment under appeal, the General Court actually applied, Lloyds said, a very limited standard of review, as distinct from that arising in the Tetra Laval case. So there was a complaint there that the General Court had adopted too low a standard of review, and that submission was dealt with by the Court of Justice, which reflected the way that it saw its judicial function over the page, 1066, at paragraphs 155 and 156, which are key. So at page 1066, halfway down, 155 says, as regards the extent of judicial review, it's apparent from EU case law that where the General Court is seized of an action for annulment of a decision, the General Court must, as a general rule, undertake, on the basis of the evidence adduced by the applicant in support of the pleas, a full review of the question whether or not the conditions for the application of that provision are met. And then after the quotes, the General Court must also establish of its own motion the Commission's stated reasons for its decision. And then you have 156. In carrying out such a review, the General Court can't use the Commission's margin of discretion by virtue of the role assigned to it in competition policy by the European treaties as a basis for dispensing with the conduct of an in-depth review of the law and of the facts. And that concludes that part of my address relating to the European Court of Judgments. Now, I'm anxious to make progress, so with your Lordship's permission, I'll continue on the next topic for a few minutes. This is my third topic, the scheme's claims that the Court of Appeal committed what I'll call a Crean-type error, referring to the Crean case decided by the House of Lords. There are, in fact, two propositions to come out of the Crean authority. The first one is indeed the proposition on which the schemes rely, which is that a national court in a damages action mustn't substitute for its own factual assessment a factual assessment by the European Commission in a different set of proceedings. And that also applies to what Judge Preck has called facts of an economic nature. Judge Preck was the reporting judge in the General Court in the MasterCard case, who was the author of an academic article that was provided to this court shortly before the hearing. In the interest of time, I shan't be going to that, but you will see in it, I invite you to look at page 357, that he describes the point that facts of an economic nature, such as whether a market is foreclosed to competition, for example, are matters on which, matters of fact, on which the judicial body faced with an assessment must make its own decision. If I may invite the court, please, to turn up Crean now. This is in Authorities Bundle 1 at tab 9. I'll just make a number of short points and then conclude for today, if I may. So this is page 319 in Authorities Bundle 1. There you have Lord Bingham describing the divisive question in the case. First line, should the trial judge have treated the Commission's factual assessment of the United Kingdom beer market and various other decisions as effectively binding on him, although not formally so? And then you have the beginning of the quotation of the submissions made by Crean's counsel. In this case, was it difficult because of beer ties and similar agreements for aspiring entrants to gain access to the market? It's a pure factual matter. And Crean in the House of Lords establishes that national courts mustn't borrow the factual basis for a decision which has been reached by a community institution when it's considering an issue between different parties with a different subject matter. Briefly, the second proposition is something implicit in the House of Lords judgment. It's the recognition that what the Court of Justice does on occasion is give authoritative legal guidance on how to apply the treaty, not only in general terms, but also in relation to highly specific categories or types of economic activity, such as, in that case, the striking of beer supply agreements. And the reference there is on page 324 in that judgment, Lord Hoffman's opinion, at paragraph 26, where you will see in the second sentence, Lord Hoffman said, in delimitis, this is just above letter G, the Court of Justice had given authoritative guidance, it must mean legal guidance, in the context of a German beer supply agreement on the conditions which had to be satisfied for the treaty article to apply, and those are then set out. So that is merely to say that in this area, the Court of Justice can and does occasionally address specific categories. My Lords, perhaps it's a convenient moment and I'll pick up tomorrow.
Yes, thank you very much. We'll adjourn until 10:30 tomorrow.